Well, it is our great pleasure today to have Senator Russ Feingold, who is the president of the American Constitution Society, as Michelle has pointed out. Such a terrific organization. We are thrilled by his presence today. He served as a United States Senator from Wisconsin from 1993 to 2011. He was a Wisconsin State Senator from 1983 to 1993, and from 2013 to 2015 served as the United States Special Envoy to the Great Lakes region of Africa and the Democratic Republic of the Congo. During his 18 years in the United States Senate, Senator Feingold was ranked 6th in the Senate for bipartisan voting. What a record, what an incredible thing as we look at 2022 and where we are on bipartisan voting. He served on the Judiciary, Foreign Relations, Budget, and Intelligence Committees, and he was chairman of or ranking member of the Constitution Subcommittee. And at the request of Chairwoman Carolyn Maloney, Senator Feingold recently prepared a legal analysis of the authority of the Archivist of the United States to certify and publish the Equal Rights Amendment, which is why we've invited him today to tell us about his opinion and really to give us some guidance on what he views are the next steps. Senator Feingold, thanks so much for being here.
Thank you so much. It's truly an honor to speak to this group. You're a critical group for purposes of this cause, obviously, and I'm honored to speak to you. Your organization has been doing hard work for years, and the momentum and the movement we are seeing right now, recently, are in no small part due to your consistent advocacy. So I find this very, frankly, surprising and exciting to see all this happening at this point. So for me, in connection to the ERA, as a former state legislator, a U.S. senator, law professor, and now president of the American Constitution Society, I've had a chance to look at the ERA in a lot of ways. I voted for the ERA ratification in the Wisconsin legislature. That tells you how long I've been around. And that was the easiest vote I ever took. We assumed it would go through. We thought it was on its way, and you know the history there. Now, our organization, the American Constitution Society, is a 501c3 nonprofit, and we are committed to ensuring that the U.S. Constitution and our laws and legal system are forces to protect our democratic legitimacy and improve the lives of all people. And we believe that the recognition of the ratification of the ERA as part of the Constitution, as the 28th Amendment, is a very important part of that mission. And we have some 40,000 lawyers and law students across the country who are part of this. But the way I came to the conclusion that I want to share with you, and that is basically that this is already part of the Constitution and should be recognized, came in a very strange way. I decided after I was asked to teach a year at Yale Law, or to teach at Yale Law School, to do a seminar on Article 5 of the Constitution and how it works, the constitutional amending mechanism. And I'll be honest with you, I taught that whole course. It was a wonderful course. And we never even mentioned the ERA, because I think back in 2017, I think most of us felt that it just wasn't going to happen, that it couldn't happen. But then I ended up getting the chance to visit at Stanford Law School, and I decided to teach the seminar again. And a friend of mine said, "Oh, I've got a friend who's trying to get the last 3 states to ratify the ERA, so it would be 38. So we had Kamala Lopez come to the class in 2018. She said, "I'm working on this thing." And she said, by a year from now, we will have changed the legislature in Virginia. They will have ratified the ERA, and there will be 38 states, and we will be in court. So I brought her back a year later, and everything she said was true. That's exactly what happened. And that's how I came to the point of sort of looking at this first, really from more of a scholarly point of view, trying to determine whether time limits put on by Congress are legitimate, whether all these things can be done. And my conclusion, after all these years of looking at this, and which we've publicized at the request of Congressman Maloney, is that the ERA has met all constitutional requirements, and that the archivist can and should certify and publish the ERA immediately as the 28th Amendment to the U.S. Constitution. Article 5 of the Constitution plainly states that once 2/3 of each chamber of Congress deems it's necessary to propose an amendment to the Constitution, the amendment shall be considered part of the Constitution when it's ratified by the legislatures of 3/4 of the states. There is no reference to time limits on the amendments, although I know they have existed in the past. My view is that the courts haven't ever seriously addressed whether those kinds of time limits are legitimate. They certainly were never used until the 20th century and not in the 19th century. As you know, in 1972, Congress passed House Joint Resolution 208, proposing and sending the ERA to state legislatures for ratification. The bill easily passed both chambers of Congress, well above the 3/4 or 2/3 requirement. And in 2020, as I said, Virginia became the 38th state. So I think that the ERA has met the language of the Constitution. And the language of the Constitution is whether or not it has met all requirements prescribed in Article 5 and should be considered, quote, valid to all intents and purposes as part of the Constitution. So you might say, well, the courts in the past have suggested that possibly there could be time limits and that those should be respected. Well, the 7-year deadline found in House Joint Resolution 208, and then the later extension of the time limit, was placed by Congress not in the amendment itself, as you probably know, not in the text that the states voted on, but only in the preamble of the bill. And therefore, that language was of timing was not put before the states as part of the ratification process, which I think the Constitution requires. I understand that you were joined in the past by former Stanford Law School Dean and Professor Kathleen Sullivan on a recent call. And I found the amicus brief that she and other constitutional scholars filed in the ongoing state attorney general legislation to be particularly compelling on this point. I assume she covered the issue very well, so I won't rehash it here, but I do want to express my agreement with her and our former University of Wisconsin professor, Victoria Norris, who also came to the same conclusion. And these are two of the most distinguished constitutional scholars in the country. Professor Norris testified before the House Oversight Committee last year that the deadline appears only in the prefatory language and therefore was not properly before the states for their consideration. I agree with this conclusion, and as such, I believe that states are not bound by deadlines found only in the preface. So if you put the timeline right in the language of the amendment, that's probably a different story, but that's not what was done here. For these reasons, I believe that the post-1982 ratifications, in other words, after the deadline by Nevada, Illinois, and Virginia are valid and therefore constitute the 36, 37, and 38 states. Now, what is the responsibility of this person known as the archivist? I mean, as we've said at ACS, who knew that the archivist would ever be important in any of these situations? But it turns out that the archivist does have that constitutional responsibility to deem an amendment ratified. The president has no role in the constitutional amendment process. The president doesn't sign the amendment. This process goes to the Congress or goes through a constitutional convention, is ratified by the states, and then the archivist is supposed to take note of it and publish it as part of the Constitution. So we hand out at ACS these little pocket constitutions. My belief is it should be in this thing right now. Every time you see a constitution, it should say the 28th Amendment. So having received the certificates of ratification from the requisite 38 states, my view is that the archivist should certify and publish the ERA as the 28th Amendment. Article 5 creates no role for the executive branch in the amendment process, and the archivist's limited ministerial responsibilities are governed by federal statute. He does not have discretion to decide whether he likes the amendment or not, or whether it's in proper form or not. He has a responsibility to do this in a ministerial way. The National Archives and Records Administration, which the archivist of the United States leads, has acknowledged that they have received official notice of ratification from all 38 states. And yet the archivist has not fulfilled his duty to certify and publish. I'm going to go one more level of nerdiness here on this because it's relevant, but this is the question, the last question of what about the memo by the Office of Legal Counsel under the Trump administration on this matter, which kind of led to this problem with the archivist. As you know, the archivist has so far refrained from certifying and publishing the ERA because of a 2020 Department of Justice Office of Legal Counsel slip opinion. Now, that's not the law of the land, but it is the law for the executive branch. when one of those is issued. And it concluded that the deadline for ratification had passed and could not be revived by Congress. In other words, the opposite of what I think the law is, but that's what the Trump administration OLC said. We have been pushing as an organization for over the entire 2 years that I've been president of ACS for the Biden administration to undo this legal opinion. To have the OLC needs to get rid of this. It was done for partisan reasons, and I think it's wrong as a matter of law. And so I'm grateful that the new head of the OLC chose to review this highly flawed opinion and has actually moved in the direction of changing it. I wish they had already gone farther and fully rescinding the 2020 memo, but I agree with their recent 2022 slip opinion that concludes that, quote, the 2020 OLC opinion will not be the last word on the constitutional status of the ERA, and that, quote, the 2020 OLC opinion does not preclude the House or the Senate from taking further action regarding the ratification of the ERA. So, of course, I'm well aware that you have been discussing and will discuss the legislation that relates to this. My view, our view is the legislation is not necessary, that you don't have to formally eliminate the time limits because they aren't valid. However, it would probably be ideal and better, since this will certainly go before the courts, if the Congress voted to eliminate the time limits that they put in place. And I know the House is fine on this, but the Senate, it's tougher going. So it's a tough strategic question of whether and to what extent doing that would help this situation. One would think it would. Some might argue that if they try to do it and it fails, the courts might say, well, that means the time limits are valid. I'm not sure about that, but I want to at least mention it to make sure that you're aware, that I'm aware, that the battlefield is not just with the archivist, but there is a serious discussion going about this at Congress, where various members of Congress are working hard to figure out how we can make sure that 100 years of effort doesn't go down the drain. That's what we're looking at here. 100 years of effort to somehow get an equal rights amendment cannot be lost, and we need to seize the moment. So those would be my comments.
Well, we thank you so much for that. I want to open it up to the
I think Carol froze, but now we are hoping to open it up to the rest of the participants for questions, which I think there will be many, and everything that you have said is welcome.
We already have two. Michelle had her hand up first, if you don't mind unmuting.
Thank you so much. Thank you, former Senator Feingold, for talking with us. You know, that the ACS is such an important leadership organization on constitutional issues. And I really liked your letter regarding the ERA. Thank you for that. Last spring, I had a friendly hour-long debate regarding the ERA and Article 5 with a constitutional scholar named Akil Reed-Amar. And he seemed to agree with me on most issues, but was skeptical about an outcome via the Supreme Court. And I want to mention that AJ Conroy, also an attorney who's on this call, and I delivered a recent really successful presentation to the Chicago Bar Association regarding constitutional issues in the ERA. And I've got an article that'll come out next month in the CBA's journal that I'd really like to share with you. And I believe it conclusively proves, based on the late Justice Scalia's tools of originalism and textualism, that the ERA is the 28th Amendment. And much of the research I did, by the way, was thanks to John Kaminsky, his constitutional archives at the University of Wisconsin, which are phenomenal. And I just wanted to say that I think the biggest stumbling block with people in power, particularly the folks who are supposed to be friendly to us, were those extension hearings from 1978. And I believe that the extension hearings was a strategic matter where folks thought that, you know, the best way to move the ERA forward was just to get an extension because they thought they had enough friendly folks. But I think that people in power, including Attorney General Merrick Garland, who apparently was involved with those hearings, Certainly then Senator Biden, who was involved with the hearings, and then Columbia law professor Ruth Bader Ginsburg, late Supreme Court justice. I think that they conflated the strategy and the advocacy with the answer on the Congress's ability to set a deadline unilaterally. And I really think that the ACS could perhaps help us educate the people who are supposed to be friendly to us on this. So I really appreciate your letter. And also I implore you, with your history of bipartisanship, to see if you could help us with some of these moderate senators, because we really need to get more of these folks over, more than just Senators Murkowski and Collins. Thank you very much.
Well, that's exactly what we are doing and what I was doing yesterday. Trying to get senators for the first time to get their arms around this point, that this limitation that Congress put into place probably isn't even valid and shouldn't be there. And then they're like me, basically. They thought this thing was gone. And so the first thing you have to do is let them know what's happened and that it's been ratified by 38 states, and to get them in a position where they might be willing to support a legislation that would make that clear or recognized by Congress. I still think there might be a couple of Republicans that would join in this. I'm not at all sure that this is an entirely a partisan situation. So yeah, and I know Professor Amar, he helped me create my course on Article 5 when I taught at Yale. But I think it's just sort of wrong to think that the Supreme Court would necessarily say, oh, no, it's perfectly fine for Congress to do this. In fact, this may fall under the Supreme Court's political doctrine, political question doctrine, which is one where they stay away from it. In other words, the archivist could say it's part of the Constitution and publish it as such. Certainly that would be challenged. And the court may decide not to touch it because it's not clear that the court has any particular authority in this area unless they see some flaw in the ratification process. So I'm not sure there would ever be a decision like that. And the problem is a lot of people would argue that the amendment maybe was invalid, but if it is published as part of the Constitution officially by the archivist, the presumption is its validity. Now, one of the things I'm hearing, and I think some of you told me this, is that in various lawsuits now that are being filed on various women's issues and others, people are starting to actually cite the amendment as law as an argument. And so that's one way in which this may come up as litigation, and then the court will perhaps have to address it that way.
Thank you, Senator Feingold. Jessica Newworth is the next question.
Thank you, Senator Feingold. Thank you for the letter and for your analysis. And I'd be interested to know, what you think the realistic chances are of getting 8 more Republican senators based on your conversations. But my questions really are more about the court case filed by the 3 recently ratified states. And as I'm sure you know, the district court found and relied on the fact that heavily that the publication by the archivist is not legally significant. So in light of that, I guess I find myself wondering again and again, why so much resistance in the Biden administration to just letting him or asking him to publish the amendment? It's just odd, with so much support having been expressed for the ERA, that there's so much resistance to that. And I wonder if you have any insight on that. And then further to that, if they were to do that, what do you think the significance of that would be to the case? And how do you feel about the way in which the Biden administration is now handling the defense of that case? Thanks.
Thank you. That's a critical question. Well, this was a suit by the 3 states that ratified after the deadline, and Virginia was the lead. Now, Virginia's going to be out of it because they have a new governor and they have a new attorney general, and they're going to withdraw. And so, but it'll still continue with the other states, and they can't undo their ratification. It is generally viewed that once ratified, you can't unratify. So it's not like the new legislature could do that. Having said that, we began the process of, as soon as the Biden administration came in, of talking to the White House counsel's office, talking to the Attorney General's office, and saying, what can be done to undo this OLC opinion? Because you are absolutely right. It was cited 14 times by the judge as a reason why he couldn't do what we think ought to be done. So my view is it would make a big difference, it would help in the litigation if that opinion was removed, because then the archivist would be basically compelled to say, look, this is in the Constitution. And I think that would have an impact, a significant impact on the litigation. Now, as to what the Biden administration is doing, I think this was news to them when they came in. This was not something that was at all on their radar screen. I'm sure of that based on all the different people I've talked to. But I consider the fact that almost immediately after the new head of the OLC was confirmed, he wasn't confirmed until just a few months ago. Well, almost immediately, they issued this thing that started to move away from the OLC opinion. So what the White House will tell you is, and they're right, they're not supposed to order the OLC to change its opinion, because in theory, the OLC, Office of Legal Counsel, has an independent professional legal opinions. And the president shouldn't be able to just order you to change it. On the other hand, it is so blatantly wrong and so blatantly political that I think they are moving in the right direction on this. And I don't think that, I'm still hopeful that one of these days we'll wake up and they will have removed that OLC opinion. And I think keeping the pressure on politically to do so is right. And this is where your organization or your coalition is the key. That women and Americans in general are very closely watching this and now believe that they now have this as part of the Constitution. I think the administration needs to understand that the consciousness of this is high. I think that'll have an impact to do even more.
Could I just ask one very quick follow-up question? I'm sorry. I mean, the OLC opinion is technically advisory, right?
Right.
Do you believe that it's absolutely essential for that OLC opinion to be withdrawn or changed for the Biden administration to say, look, that Trump opinion was politically motivated. It has no validity. It's not really well-founded legally. We're just not taking that advice and bypass that.
I think the White House could indicate its concerns about the opinion and even cite the OLC slip opinion that just came out in that regard. And I think the president could reiterate that he, or say specifically that he believes it is part of the Constitution now. I think that would be helpful.
Great, thank you, Jessica. And we have 3 more questions, and then I think we'll have to end it with that, just out of respect for the senator's time. So it'll be Lisa, then next.
Great, thanks, Bettina. Thanks, Senator, for being here. I was on the VA Ratified ERA campaign leadership team, now part of the ERA Coalition Advisory Team, and then subsequently on the Biden for President domestic policy team before he was elected, and wrote the ERA brief for the transition team. So my question to you piggybacks on what Jessica was asking, but is more specific in terms of action. So with 27A, right, Don Wilson is the only archivist to ever have gone and certified an amendment. And though unnecessary, Congress came back and validated it. Is it worth it, do you think? And would you be willing, before 4/22, April 22nd, when David Ferriero retires, to have a visit with Archivist Ferriero and Don Wilson before he retires, sit down and maybe have a meeting? And do you think if you had a meeting, and in your opinion, could ratification, or rather certification and publication by Ferriero, perhaps with pressure from you, I'm being a little hopeful here, and Mr. Wilson, do you think that then that would cause swift action by Congress to validate, as they did with 27A, although of course congressional pay raises was a bit of an embarrassment to Congress? Thank you.
To be honest with you, I don't think my doing that would turn the whole thing around, but I would be perfectly happy to. I think it might be better to do it with a new archivist who will be coming in.
But the acting archivist won't have the same level of responsibility until a permanent archivist is confirmed,
Right.
correct?
No, and,
And so-
that should be one of the priorities, is to get a new archivist confirmed so that we have somebody who doesn't have this record. I know a number of people, I think people on this call have already met with the archivist. I sent them formal opinion of the archivist. You should do the right thing, but I don't think simply a meeting before April 22nd is likely to produce that result. But I would strategize in terms of everything we can do with the interim and the next archivist to get this done.
And I expect that will be a confirmation question too. So that's going to be dicey.
That will be very important.
but you would be willing to try to sit down with
Oh,
Mary
sure.
Era before his retirement? Okay, great. Thank you, sir.
Fantastic. Thank you so much. Natalie and then Jimmy.
Hi, thank you so much for Bettina for letting me ask a question. And thank you so much, former Senator Feingold, for all of the work that you do. My question is, in your legal opinion, is ERA currently law? And second question, if it is, how important is publication if ERA is law?
Well, I do think it's the law. I do think it's been validly ratified. I think people are fine to be able to raise it in lawsuits. I think counsel on the opposite side would say, well, it's not in this, it's not in this document I have in front of me here. It's not in the Constitution. But then the court would have to get into that issue. But I think it's best to conduct ourselves as to what we believe, that it is the valid law of the United States. And somebody's going to have to undo that. Somebody's going to have to somehow get to the Supreme Court and have them say, no, it's not. In other words, we should take the presumption and the position that it is in the Constitution and treat it as the law of the land.
So if ERA is law, is it really so important to be fighting for publication? Of course, we should be fighting for publication. But if ERA is law, how important is publication to ERA being law?
I think it's well worth fighting for.
No, I think it's definitely worth fighting for. My
think-
question is,
I think it's important in terms of public perception. A lot of this
Right.
stuff about the Constitution has to do with legitimacy and the public perception. I think every school kid in this country should get one of these that has the 28th Amendment and be taught that women have equal rights under the Constitution. And I think without the publication, you're missing something important politically. So I think it's an important fight. I don't think it's essential legally, but I think it's really important in many other ways.
Great. Thank you, Senator. And Jimmy,
Okay.
to you.
Thank you for being with us today. And you brought it up, so I will put it right out there. Politically speaking, we are furious that the Biden administration hasn't gone forward and endorsed ERA as published. If we go to the interim archivist and that hearing process, which we know will be an absolute circus, thank you, Republicans, I think there is a problem of jeopardizing Democratic votes in the midterm election. I'll just put it out there. Women want this done and talked about and out there before this fall.
Well, you can imagine that when I've spoken to people about this, I don't just talk about the law, I talk about the fact that this is an enormously important issue from a political point of view. We don't focus on the political side in our organization, but having a long career as an elected official for 28 years, I guarantee you, this is a very serious issue. The thing I would say is that the Biden administration is not even halfway through. That they are able to do this at different points in time. I would like it done now, and we would like it done now. But I don't think you have to consider that the game is completely over if it doesn't happen before the midterms, which it should. But it's not over then, and it doesn't really matter as much if obviously if he's still president. If there's a change in the House and the Senate, yes, the legislation might not go through, but you don't need the legislation under my view here, under this interpretation. So you still go to the administration and say, look, acknowledge that this is in the Constitution, get rid of that OLC opinion and have it published by the archivist to say it is.
Thank you so much, Senator Feingold. And I want to say how important your voice is in this. And so any way that we could work together, work with the American Constitution Society would be so appreciated, both in our work for the archivist, our work for the Senate. Two of our Senate targets are Senator Shelby and Senator Burr, who I know you were in the Senate with, as we go into a vote, which we're hoping to see in May. So so your partnership and your advocacy and your voice, I don't know if I'm allowed to say advocacy, but your voice on this is so important to us, and we truly appreciate it. Carol, did you?
I just want to add a thank you, and we will certainly be in touch. Thank you for the wonderful work that the society is doing. So we'll be in touch. Thank you.
Thank
so
you.
much.
We're happy to help in any way we can. We love this topic and we think it's terribly important. So thank you for your leadership. Nice being here.
Thank you so
Very
much.
good.